Welcome to the Commonwealth Policy Center Candidate Forum. And with me on this edition is State Senator Whitney Westerfield. He is District 1 candidate for the state Supreme Court. Whitney, welcome to the program.
Thanks for having me, Richard. I appreciate it.
So, Whitney, you are from Hopkinsville. You have served in the state Senate for 7 years now. Tell us a little bit and tell the viewers a little bit about your background, family history, work history. Go ahead.
Well, as soon as I got out of law school, I came back to work in Hopkinsville as a prosecutor. Was an assistant Commonwealth attorney there in Hopkinsville for a little over 5 years, prosecuting everything from homicides to misdemeanors, everywhere in between. And then felt led to run for the state Senate and ran in 2012 against a 20-year incumbent that no one thought could be beaten, including members of my family. Mm-hmm. And God blessed me with a victory. And I've been able to serve in the state Senate for the last 7 years and have chaired the Senate Judiciary Committee, which is of significance given the race that I'm in, since my first day on the job in the state Senate.
So tell us about some of the accomplishments that you have made in the state Senate. What are some of the achievements or milestone bills that you have sponsored?
I think at the top of that list would have to be pro-life legislation. That's something I campaigned on in 2012. It's something that's very closely held belief for me, and I've been instrumental, along with many other legislators who believe in protecting the lives of the unborn. And so I've either sponsored or co-sponsored or helped author and helped pass and certainly voted for any number of pro-life pieces of legislation through the Kentucky General Assembly.
Kentucky has seen a renaissance, is what I call it, of pro-life legislation. In the last 3.5 years, there have been 8 different pro-life bills that have been enacted into law. I think you've sponsored or co-sponsored, or at least co-sponsored most of those, if I'm not mistaken. You did sponsor a bill this last legislative session that would have banned essentially infanticide, as I understand it. Tell us a little bit about that bill.
Well, we've seen what sort of truly evil remarks, the rhetoric, and the beliefs that have come out of sitting governors. Ralph Northam in Virginia, the governor in New York, where they have championed and celebrated infanticide. So
Ralph Northam, Virginia's governor, was interviewed earlier this year, and he essentially, it was a live radio interview.
It was.
He essentially said that if there's a baby that survives a botched abortion, that the decision to allow that baby that's actually come into the world, the decision to allow that baby to live should be between the mother and the doctor. And your bill was a response to that?
It was. There was a lot of debate at that time around the country about how many states have protections. Kentucky's not one of the states that does. Mm-hmm. And so I immediately sought to have a bill filed. We filed it, got it through the Senate, got it to the House. I'm still frustrated it didn't make it out of the House in 2019, but I hope we pass it in 2020. And I hope somebody else from the 3rd Senate District's there to carry it or vote for it, because Kentucky ought to have those protections. If there's a child that's born alive from a failed abortion, it's a human life that has dignity, that deserves medical care, and should be protected, not left on a table to die cold and alone. And it's disturbing when we see the news stories around the country where other states celebrate the choice to do that, and I think letting that child die is evil.
So when you say other states celebrating the choice to do that, are you referring to New York's legislature that stood up in applause once they passed a constitutional amendment that allowed for the abortion up to the 9th month of pregnancy?
It's disturbing. It's very alarming to see such a callous response to life, and it's widespread. Thankfully, it's not here.
So would you see Kentucky as a pro-life state?
Absolutely. Certainly more pro-life in the last 3 or 4 years with the election of Governor Matt Bevin, but I'm thankful to serve in a state Senate right now that champions life.
Whitney, I want to bring this to the race for Supreme Court Justice.
Of course.
How do you see the life issue factoring in? If you were elected to the state Supreme Court, do you see cases coming before you dealing with the life issue?
Ordinarily not. Ordinarily, these cases are filed in federal court. There have been other jurisdictions where these sorts of actions on pro-life legislation have been filed in state courts. Mm-hmm. That might be a trend that we see, particularly if Roe is ever overturned at the federal level. So it's still something that could obviously come before the Kentucky Supreme Court. It's a state piece of legislation. A challenge could be posed there at any time.
Okay. I want to talk about the traits of a good judicial candidate, or the traits of a good Supreme Court justice, I should say. What are some of those traits that a good justice will have?
A Supreme Court justice ought to be someone who's prepared to uphold and defend the rule of law and the law as it's written. Okay. There's a great quote from then Judge Gorsuch, and he was going through his confirmation proceeding hearings back in 2017. And he said a judge shouldn't try to stretch the law for an outcome they'd like instead of one the law demands. And I completely agree with that. There's another great quote from the late Justice Scalia, and if folks listening to this haven't, you ought to go buy the book Scalia Speaks. That's a book by his son that's compiled a bunch of his public remarks. And there's a quote in there wherein the late Justice Scalia said something to this effect. He said, "A people can reasonably be expected to choose lawyers to decide what the Constitution means, but not what the Constitution ought to say. That's not a job for lawyers, but for the people." And I think that nails it on the head. I think judges should stick to what the law is. And sometimes the result feels good and everybody's happy, and sometimes the result stinks. But you apply the law. You don't get to pick and choose whether to do that. You don't get to add to the law or extrapolate beyond what's codified and been voted on by the lawmakers and policymakers.
Sure. And what you're referring to is something that's known as judicial activism, where a judge brings their policy preferences into a case, and they stretch the law, as you're talking about.
We see it all over the country, and we see it here. I'll give you a perfect for instance. With our Supreme Court, there have been cases that they've rendered this year, rulings.
The state Supreme Court.
The Kentucky Supreme Court, where they've relied on and have quoted at length the constitutional debates. Well, the constitutional debates might be really interesting reading. Probably are is really interesting reading. But no one voted on what that one legislator said back in 1891. No one voted on whatever those comments were. And the comments of this one legislator or this one other person don't speak for the entire Kentucky General Assembly and the Constitutional Convention and the legislature at the time. That's not the law. My opponent, for whom I have a great deal of respect, has also done that. There have been cases. There's a case out of Trimble County where he, on the Court of Appeals, went beyond. This is a case where LG&E has a coal-fired electric plant in Trimble County, and they sought a permit to discharge water into the Ohio River. They were issued the permit by the state environmental cabinet, acting on authority by the Clean Water Act through the EPA. And they got the permit issued. It made it to the Court of Appeals, and my opponent ruled that with another judge on that 3-judge panel. He was part of the 2 judges that issued the opinion of the court that said, you've got to do not just what the Clean Water Act says now, but these extra steps here. And the Supreme Court got that one right. Our Kentucky Supreme Court reversed it unanimously, saying that no matter how tempting shortcuts might be, permit writers have to apply the law they've got, not the law they want. That's judicial activism, going beyond what's on the page.
So, Whitney, you had used a phrase just a few moments ago called the rule of law. You believe that a good state Supreme Court justice, maybe just a good judge, will apply or believes in the rule of law. So what is the rule of law? How do you understand the idea of the rule of law? We hear it a lot, but what does that mean?
Well, I think the law, it's what the people's branch of government has duly enacted, what our chief executive of our state government has signed into law, or if it's a constitutional amendment, what the voters have themselves ratified. Mm-hmm. That law sits before us. Judges have absolutely no authority to change it and shouldn't exercise authority to try to change it. The rule of law exists to protect and to establish the parameters that we're all supposed to live within. When cases come before the Supreme Court, the justices should apply the law that's there and let the policymaking be left to the policymakers.
So what I'm hearing on one side is that the judges don't make the law. This is part of the idea of the rule of law. They apply the law. I'm also hearing that people have input when it comes to a constitutional amendment process. They have their say. They can vote for or against a proposal that's on the ballot. And
they have their say at the ballot box for their duly elected representatives who serve in this building. They get to vote on the senator or representative that are going to represent the interests that they want for their district. The voters are ultimately the deciders of what the rule of law ends up being made by the policymakers and by the executive branch enforcing that. The courts have no voice in that process, and it should stay that way.
I want to bring in another aspect of the rule of law, and that's that: is there a higher law to which we're bound by? Is there a higher authority by which we derive ideas of right and wrong? A higher authority that
there is for me,
okay,
and there is for you, but there may not be for other people.
Okay, so how does that factor in? And by the way, I would say that it's an American idea that not just the founding fathers recognized this in the Declaration that there's a creator that endows us with inalienable human rights. They certainly did. So that there is a higher law, according to the founding fathers in our Declaration of Independence. They relied on the laws of nature, and nature is God. So they did believe in the rule of law, that there was a higher law. And that's foreign to many of us today, or foreign to at least our culture. We don't hear that.
It's entirely foreign to the culture. Which is regrettable.
So with that understanding, how do you apply some of that American understanding, the founding fathers' understanding of that there is a higher law, there's a creator that endows us with rights? How would that inform your judicial decisions if you were elected to the state Supreme Court?
Well, I think it informs everything, not just my judicial decisions, not just my legislative work, my time as a husband and a father. Just now realized that when you asked the very first question to say something about my family, I never got around to talking about.
Go ahead and share it now.
To my wife Amanda, who I love, and who is the director of the Pregnancy Care Center in Hopkinsville, and to our two beautiful children who God blessed us with through adoption, through a traditional adoption and an embryo adoption. Super important to me, most important thing to me in my life on this earth is my wife and my kids and my family. So. I think relying on that is important to me. I can't rule in such a way that I push my belief system and my faith on other people, but I think that guides my decisions when it comes to certain policies as a policymaker. As a judge, I can't use that the same way I do as a policymaker. When I decided to run for the court, I had to be willing to put my policymaking hat aside and take it off forever for good, and be willing to stick to the law. And so there might be instances where I've got to apply the law that exists on paper, even if it disagrees with the way Whitney feels personally about an issue. So it's a different experience and a different way of using and relying on my faith than it is as a policymaker.
Whitney, could you identify a court opinion, whether it's at the state level or federal level, that you strongly agree with? And then I'm going to ask also a court opinion that you strongly disagree with, and then why? So maybe give us one of each. Give us an example of.
Well, there's a slew of opinions that I disagree with.
Let's start with that. Tell us an opinion of court, whether it's
you prefer the state or the federal.
Either one is okay. I think more people probably recognize a federal court ruling.
Yeah,
that's what they pay attention to.
I think at the top of the list would probably have to be Roe.
And Roe v. Wade was the 1973 decision that legalized abortion on demand in all 50 states.
And of course, there are other cases that have followed in that, Casey, and other cases that have built on Roe or tweaked it a bit as we've gone through the years. Cases that I agree with. There's a decision that nobody's will have heard of, but it's fresh on my mind because it speaks to one of the other things. There's a connection to the Supreme Court here in Kentucky. There's a decision out of Ohio that upheld unanimously, and Scalia was still on the court. It was a 9-0 decision that upheld a rule of evidence that Ohio uses to allow hearsay evidence, hearsay testimony about child sexual assault victims to be considered for admission into evidence. Okay. We've got a slew of hearsay exceptions, so hearsay can come in under one of these exceptions, can be admitted into evidence, possibly, to be considered. But there's no way if a little child victim comes up to you, comes up to me or someone else or a school teacher, and in the case in Ohio, I believe it was a school teacher, and reports that mama's boyfriend did something to me a month or 2 months ago, there's no way in Kentucky for that evidence to be considered. There's no hearsay evidence or hearsay exception that allows that to come in. The reason I bring that up, and I'm thrilled with that decision, we've tried to create that similar rule here in Kentucky, and our Supreme Court refused to adopt it over my objections. Let
me interrupt if I could. Was that a legislative attempt to require them to?
We actually tried it both ways. There's a rule in the Rules of Evidence that sets up something called the Evidence Rules Review Commission. As chair of the judiciary, I sit on that, and we proposed this rule. Mm-hmm. And it went through the process last year. The Evidence Rules Review Commission made the rule better, the proposed rule. Mm-hmm. As the Supreme Court is also not just issuing rulings on the cases, they also make the rules for the practice of law for the court system. And so they undertook the decision about whether or not to adopt this rule. They elected not to adopt it. Meanwhile, the legislature in 2018 passed it anyway. I believe the legislature has that authority. Governor signed it. And in a bold act that I'm still frustrated with, that I think goes, talk about judicial activism, someone acting on behalf of the Supreme Court or at the direction of the Supreme Court actually called the publisher, Thomson Reuters, called the publisher of our statute book, our rule book, and had them requested that they strike the rule that the legislature passed and the governor enacted.
It sounds that would not be
legal. It's absolutely not within the purview of their authority. There was no case or controversy before the Supreme Court wherein they could rule and issue an opinion on the constitutionality of the rule. Mm-hmm. It was a brand new rule, but they still tried to do that. I got Thomson Reuters to agree to put a little asterisk by the rule at a minimum, which I still disagreed with because we properly enacted it. But that's, again, another example where you've got folks trying to extend their authority beyond what they're supposed to do. And in this case, it harms child sexual assault victims.
Yeah. So I want to go back to what somebody on behalf of the Kentucky State Supreme Court did. They asked the publisher to not put on the books what the legislature required.
Because the court itself didn't adopt it during their rulemaking process last summer.
So where is this controversy? Has the legislature spoken in response to that?
No, because it happened after we adjourned in 2018. The Evidence Rules Review Commission has just been reconvened to consider a new version of this rule. So we're in the process of, I made some edits. This came from a model rule somewhere else, and we're going to try to run it through the court process again.
So what I'm hearing in this, and correct me if I'm wrong, but the legislature took action to clarify what the new rules would be, and essentially
in this limited case, yes.
The court system said, we'll decide whether or not we will accept what the legislature did. It seems like not willing to accept your authority because the legislature, the legislative lawmaking branch of government, does have the authority to make laws and to make the rules, if you will. The court actually is supposed to apply the laws that the legislature takes a lead on. And of course, the governor has to sign those laws, bills into law. But it seems to be something is out of whack.
There's a debate about where the line is drawn. When the Supreme Court's authority to make rules for the court ceases to exist and the legislature can act, and vice versa. Whether or not it's a substantive rule or if it's just a procedural or mechanical rule of the court's process. And there are differing opinions about that. What bothers me, though, is that there's been no affirmative or concrete action declaring that the legislative enactment is not legal or proper. It's that someone on the court went out anyway without some underlying case or controversy before them striking it down to take the initiative to have it stricken from the rule book when we've codified it. That is very disturbing. That sort of thing. And again, it gets into another issue. Again, the rulemaking of the court is something that most people aren't thinking about. You hear about the rulings, you hear about the opinions that the court renders, and we could talk all day about that. But there's a court efficiency piece to the Supreme Court that you don't think of unless you're one of the people that have to sit and wait for months for a hearing.
I'm glad you brought that up. One of the things that we're guaranteed in the U.S. Constitution is due process. That's one of the principles. But a fair trial, a speedy trial.
That's right.
And often it takes a long period of time
Richard,
for people to have their day in court.
There are places in Kentucky where your case resolves as a function of time before you can get a hearing. And likewise, there are places where you get a hearing like that. The court system hasn't redistricted its assets of judicial appointments and positions across the state in 50 years, or maybe it's never been done. We've tried several times to do it based on objective numbers that the judges themselves have reported to the court system. I don't have a mastermind plot of a map in mind, But I do hear issues from constituents and from legislators and from judges in parts of the state where you've got substantially light dockets and then dockets that go into the night, where we're just covered up with hearings and cases. And there's got to be some way to fix that so that people have the actual constitutional right they've been given to have redress for their grievances.
That's right.
And access to the courts. And right now there's a lot of people that don't get it very fast.
Is there anything that could be done if you were on the court
Absolutely.
to address this at state Supreme
Absolutely.
Court level? Or was that more of a legislative function?
No. The court can do a whole host of things. There are some federal rules of procedure that the Supreme Court can adopt for the state courts that can help clear the cruft. There are things to do to help move redistricting of judges around and to try to sidestep the political landmines that exist there and that absolutely rear their head every time, so that people don't have to wait for their hearing to be heard, to be scheduled. There are any number of things that the Supreme Court can be doing and that I would try my hardest to do as a member of one of those 7 seats if elected.
There is a high-profile case in front of the state Supreme Court right now. It's regarding the Hands-On Original company in Lexington. Blaine Adamson was sued almost 10 years ago, I want to say, maybe 2012, for not printing a message on T-shirts that he had a religious objection to.
Unlike Christian Baker cases around the country and other similar sort of cases.
That's right, very, very similar. He has been through the court system, district, I believe, Court of Appeals. Now it's in front of the state Supreme Court. Interestingly enough, though, his case was in front of them for well over a year before they heard oral arguments, which they just heard a few weeks ago.
You just hit on another point of contention. The Supreme Court justices are the sole deciders about whether or not a case gets heard, called granting discretionary review. And there are cases that like the one you just described. There are others that's not at all an isolated incident where the case sits for a year or more than a year while they're waiting on these 7 justices to make a decision. There's a lot of things that are tied up. Litigants on both sides are tied up in their cases delayed, and the old adage that justice delayed is justice denied is absolutely correct. There are places where I know of a party right now that's waiting on their case to be heard at a certain level by the Supreme Court, rather, and their investment in a community piece of property to provide resources to the community is just sitting. They can't clear title to the property because they're waiting on the court to just decide to take it, much less on the ruling, which could take an indefinite period of time after that. It's frustrating, and that's another place where the Supreme Court could act immediately to rectify it. Shouldn't take a year.
What kind of influence would you have if you were a justice on the state Supreme Court to have over expediting hearing some of these
Make
cases?
noise. It's just the 7 people in there, and demand that this needs to be done and keep reminding them of it, and then drawing public attention to it, and reminding people and the electorate and the people across the state of Kentucky that this is an issue that needs to be addressed and that they should bring that up with their elected judge. Making noise, just like I've got to do in the Senate sometimes to get policies moving forward or to stop other policies. You advocate for the right issues. And as a judge, my issues are related to the court system and to making it equitable for all litigants, not favoring this side or that, but making it equitable for all litigants and making it efficient and smooth for all litigants. And man, there are some places where we can improve beyond what we've got.
Whitney, as we have this conversation, I appreciate your frankness in talking about some of these issues, and you have a boldness as you talk about these, maybe more so than other judicial candidates. Just across the board, one of the concerns is that if a judicial candidate speaks too much, and I'm not saying that in a negative way, boldness, but often there is a reservation for judicial candidates to speak too much on an issue for fear that if an issue comes before them, they might have to recuse themselves on that case. So we talked about the free speech issue with Hands-On Originals. There's another issue in front of the state Supreme Court, gambling expansion.
It is.
Instant racing machines have been unilaterally legitimized by the Horse Racing Commission. They're saying it's really not casino-style gambling. It's really not a video slot machine. That's an issue they're dealing with. But
that's right.
I want to know, so running in a judicial race, how comfortable or how much should a candidate talk about on these issues? Because the voters need to have some basis for voting for the candidates, but where is that? Is there a fine line? Or
there is a fine line. I don't think there's any harm in a judicial candidate letting folks know where they stand on certain issues and what they believe in.
Okay.
And as a sitting Republican state senator, it's hard to hide that even if I wanted to. And I'm proud of my record, and I don't want to hide it.
Yeah.
But you have to maintain the impartiality of the court. Okay. And you can't promise to say, and when you're campaigning, you can't promise to rule a certain way on a certain issue. Mm-hmm. Every case is different. Every law is different. Its application in every case is different. And you've got to take those cases as they come and make the decision based on the law in front of you, not how I feel. There have been cases before the Supreme Court. There are cases in front of the court now that I can't speak to because they're in front of the court. Mm-hmm. I'll give you a perfect, for instance, Marcy's Law. I supported Marcy's Law. It was my bill.
And so just so the viewers know what Marcy's Law is.
Marcy's Law is the constitutional rights for crime victims that the voters voted on in 2018 and overwhelmingly supported. There was a big hubbub on Facebook about a random issue, a hypothetical that was complete garbage and a joke, mm-hmm. That wasn't a legitimate issue. And you can talk to any prosecutor or law enforcement officer and deduce that and get that answer. But I fully support Marcy's Law. Mm-hmm. It was struck down by the court because they didn't like the ballot question. It's almost certainly going to come back up again in 2020. If the voters ratify it again, or even before November, if it gets litigated again and gets up to the Supreme Court and I'm sitting on the court, chances are I'm not going to be able to sit in judgment on that case. Right. So there are some instances where, in my case, I've been very vocal on this issue or that, and I probably would have to recuse. But otherwise, you've got to judge the cases as they come, not based on your philosophical approach to that specific issue.
So how comfortable do you feel? You identified as being pro-life earlier, so you feel comfortable saying that you're...
Absolutely. I think I'm free to say that I believe in certain things.
Man-woman marriage?
Yes.
So you're
believe,
allowed to say that?
I believe that we are allowed, and again, even if I wanted to hide that and I don't, I've been pretty obvious about that in my time in the state legislature.
Whitney, we are just about out of time. You've got a minute to tell the voters why they should vote for you for the first state justice of the Supreme Court candidate.
Well, first I'd ask you to pray. I'd ask you to pray for my family and me, and pray for my opponent and me as we finish the last few weeks of this campaign. I believe I'm the best qualified candidate. Between my time practicing law, and I've litigated in one way or another at every level of the court system in Kentucky, my 7 years as judiciary chair, the committee of jurisdiction for everything related to the court system. And I've worked on dozens of bills myself and read and moved through hundreds of others and reviewed others over the last 7 years. And also because I'm not coming as a sitting judge. I think it's important that we have fresh blood. When I talk about efficiency of the system, we don't have an abundance of judges on the court who have practiced law on the front lines since the iPhone existed. We need someone who understands what it's like to be in the practice of law today and understand the impact of the court's rulemaking power and how it hurts or helps the court system. And it usually hurts. And I think bringing that fresh perspective is important to the Supreme Court. I believe I'm the best candidate for the job. I've shown that I can uphold the rule of law as a legislator, and I'd like to continue keeping that promise as a member of the court as the next First District Justice.
All right. Whitney Westerfield, thank you so much for joining us on this edition.
It's my pleasure.
And thank you all for tuning in to the Commonwealth Policy Center's Candidate Forum. Hi, I'm Richard Nelson with the Commonwealth Policy Center. You can find more of our videos on YouTube and Vimeo. And for more information about the Commonwealth Policy Center, go to our website, commonwealthpolicycenter.org.